Hi, good day. I'm Cyrus Mansouri, and I am a solicitor who specializes, amongst a couple of other things, in matrimonial law and divorce. Now, this podcast that we're doing today is a follow on from the one that's directly above it, and it relates to the divorce petition. Now, in the previous one, if you watched, I explained the steps that you would go through to petition for a divorce. Uh, the main ground, well, the only ground for a divorce is that the marriage has irretrievably broken down. And that needs to be supported by one of five facts. Now, I mentioned in the previous podcast that those five facts they're defined in the law, and they are, in order that they appear, they are: number one, adultery; number two, unreasonable behavior; number three, 2 years separation with the consent of your spouse; number four, 5 years separation; and number five is what we call desertion, which means that your spouse has deserted you for at least, or abandoned you for at least 2 years. Now, you're going to have to choose one of these if you're petitioning for a divorce in England and Wales. It's got to be one of them. And of course, the question is now, which one is it going to be? The majority of people are going to use the first three, one of the first three. I should stress, you only need one of them. You don't need more than one of them. Even if more than one of them applies to you, one is usually enough to choose. And most people are either going to fall into the bracket of adultery or unreasonable behavior, or the third one, which is the amicable one. It's the friendly divorce. It's called 2 years separation with consent. And I think I'll talk about that one first because it's quite easy, really. It's streamlined. So many cases, you've already agreed with your partner that we're getting a divorce. The marriage is irretrievably broken down. We both agree on it. We both want to go our separate ways. Let's just get this done. Let's get it dusted, and let's get on with our lives. And that is probably the one that's going to fall into the fact of divorce, 2 years separation with consent. Now, some of you are going to be thinking, hang on, I've been separate for 2 years, we're still living at the same address, things like that. Well, that doesn't necessarily mean you can't use it, okay? Because you can still live at the same address and you can still live under the same roof, but you could be separated. Now, the separation, as far as the divorce court is concerned, that word basically means that you don't have a common life together. Okay, so just because you're both living at the same address doesn't mean that you're not separated. You can be. The point is, do you both agree that you've been psychologically and materially living separate lives for at least 2 years? That's the key. If you both agree on that, and you can put that date in there that's at least 2 years ago and say that as of this date we have not had a mutual, matrimonial life together, then you can use this ground. And let's be honest, I also get asked quite a lot of times. People think that if they had a romantic involvement with their spouse at some time over these last 2 years, then that rewinds the clock. Well, it doesn't. No, it doesn't. You only rewind the clock if you have a period of 6 months continuous cohabitation. So one day, one night, 1 week is not going to make a difference. You need to say that we have cohabited for 6 months, which basically means, although you were under the same roof to start with, it basically means that the marriage resumed in a normal sense of the word, and it continued for another 6 months before we again came to the conclusion that we want to get a divorce. So yes, some minor indiscretions between the two of you are not going to affect that ground. So it's the good one to use if you both agree on it and it's easy. But I stress, your spouse is going to have to sign their consent to this. If there's any question of them not signing for it, then this fact is not going to help you. It's not going to apply to you, and your divorce petition is going to get stuck. And you'll probably need a solicitor to get it moving again from that point, because it's quite complicated. I'm going to go now to the first point, which is adultery, and I might also be overlapping this with unreasonable behaviour, and I'll explain why. So very often you're going to come to your lawyer and you're going to say, my spouse has been adulterous. They've had, 1, 2, 3, 4, 5 different relationships. Doesn't particularly matter as far as the law is concerned. It can be a single relationship, but that you'll come and you'll be saying that you're furious about it, you're very angry, you're very upset, and this is really the main ground why your marriage is breaking down, because your partner has had an adulterous relationship. Now, this might be obvious, but I need to say it. It's only adultery if your partner did it. Okay, so you can't divorce on the basis of your own adultery. Can't say I was adulterous, so I want a divorce. So it's got to be your partner that did it. And secondly, for some strange, quirky reason of the law, and don't ask me why, it's only adultery under this particular paragraph if it happened between your partner and a person of the opposite sex. Okay, so I do need to mention that, because in very few cases that is relevant. Now, if you're going for adultery, it's going to be hotly contentious, isn't it? Let's face it. Your partner's going to get a divorce petition accusing them of adultery, and if anything's going to get them upset, it's going to be that. Now, they may get upset because they simply don't agree. They don't admit it. They say it never happened. You say it happened. They say it didn't happen. Or they may get upset because they take the view, well, why did you do that? Why did you say this? You've humiliated me. Why? You didn't need to point out all the details. So it's the point that's most likely to rile them up. Some adulterers are perfectly happy to accept it. Some of them will just look at it, and I've often been consulted by respondents who are being divorced on the grounds of adultery, and they'll say, yeah, I did it. I admit. So everybody's different, but you need to bear in mind that adultery is the one that's probably going to really grind the whole subject quite roughly. So it's not the one to pick if you're looking for amicable settlements. If you are going for adultery, you're going to be given the option of naming the adulterous party. If you know who they are, do you want to name them? It's your call. The more information you put in here, the more contentious this whole thing can potentially become, especially if that adulterous party might have a spouse of their own and they've ended up being named in a court case. So it's really your call. I would suggest, if you really are this deep into the details of your divorce petition, it's probably a good call to get some advice, some specialist advice, because there's a lot of ifs and do's and don'ts and buts and maybes. So you need to think about it. But you can name them. And if you do name them, you can also seek the cost of your divorce from the adulterer. And again, that's yet another subject. So if that again is something that you feel very strongly about, then perhaps you should consider taking a consultation with a lawyer, with a solicitor. They'll tell you the benefits and disadvantages and what have you of going down that route. And they'll also tell you that if ever there was a case that's likely to become contentious and cost more money and end up being disputed, it's probably this scenario that we're talking about right now. So you need to think carefully. Now, the third ground, the unreasonable behavior, this is connected to adultery, because very often I get consulted by people who tell me, my partner does this that really riles me. They do this something else. They really upset me. They're very unreasonable. They don't agree with this. They don't agree with that. They're rude. They're argumentative. They're violent. I don't know, whatever. They treat me horribly. And, oh yes, by the way, they've also been adulterous. Shall I go and apply under adultery? Well, you don't have to. If you don't feel very strongly about that, you don't need to. You've got lots of other reasons, and they are unreasonable behavior. That means that your partner has been behaving unreasonably. Now, you're probably wondering, what does that mean? What is unreasonable behavior? Good question. Fortunately, the answer is pretty easy. In this particular area of law, unreasonable and unreasonable behavior means whatever you say it means, you being the petitioner. So if you say that your partner refusing to do all the cooking and all the cleaning and washing your car and walking the dog and looking after the kids is unreasonable, the court will say it's unreasonable. So it's really very wide. It doesn't need to be unreasonable in the eyes of other people. So lots of other people will look at the example I just gave and think that's not unreasonable. But if you say it's unreasonable, then the court will generally side with you, because it's what's called the subjective test, which basically means if you feel it's unreasonable, it's unreasonable. It's not the objective test, which is what would other people think. Okay, so whatever you consider to be unreasonable is probably going to fit the bill. Obviously, keep it fairly logical. So the example I gave was an off the cuff example, which is terrible. Keep it reasonable, keep it logical, because if you did ever end up in front of a judge, you want to have something fairly substantial to be able to rely on. So that's unreasonable behavior. Now, adultery can be part of unreasonable behavior, so you can cite the reasons, and normally I would advise that you put in at least 5 or 6 reasons. You don't need to write War and Peace on them. You don't need to recite your entire biography. You don't need any of that. We're talking 5 points, 6 points, each one between 1 to 2 sentences long. That's all we want here, okay? Don't go writing screeds and books and whatever. Don't need it. It's not necessary. Point number 1, my spouse is constantly belittling me, diminishing me, talking down to me, and making me feel bad. Point number 2, my spouse is constantly whatever, whatever the case is. Just put that in as it is, 1 or 2 sentences, 5 or 6 reasons, and one of them could be that my spouse has been adulterous. If you feel strongly about it, you can put it in here, rather than running it on the ground, on the fact of strictly adultery. You can stick it in under unreasonable behavior and say that, oh yes, on top of all these other unreasonable things that they've done, they've also been adulterous. So it's entirely up to you. Whether you want to be naming the adulterer party in this section, that I think is an area that you now need to be careful with. Okay, and you probably shouldn't do it, because you're not strictly bringing them into the case here. Okay, and that can lay you open to problems, legal problems. So if you're not divorcing on the grounds of adultery, don't name the third party, the adulterer, under the unreasonable behavior heading. Don't do that. The remaining 2 points, which was the 5 years and the 5 years separation and the 2-year desertion, they deserve a little bit of explanation. The 5-year one, it comes up every now and then. It's obviously a case where you've lived apart for 5 years or longer. It's important in one particular respect, and that is that although the other facts don't generally affect financial settlement and your rights that you would have achieved on a financial settlement application, this one can affect that. It can have an effect. So if there is a dispute regarding finances and you have been living apart for 5 years or more, then again, this is a red flag that suggests taking specific legal advice from a professional, because there's a lot of stuff to talk about on this particular point. But if you've been apart for 5 years and this is really just a case of getting a divorce and nothing else, and there's no financial dispute and you're not expecting any financial dispute from the other side either, then by all means, it's a good ground to use. It's fairly straightforward. You don't need to be criticizing them. You don't need to be running them down with unreasonable behavior. You don't need to be giving those reasons. You just tick the box. 5 years separation. We've lived apart for at least 5 years, and that should clinch it for you. So that's that one. And then the last one, which is the desertion, the abandonment ground, which is that my spouse deserted or abandoned me at least 2 years ago, and it's continuing up until now. Well, that is unusual. We don't get them very often. The reason we don't get them very often is because usually couples will run a divorce on one of the other facts. It's just unusual. There's no specific reason. It's just uncommon. I put it like that. It's uncommon to use this one. Obviously, if it applies to you, then by all means, it could be the relevant one for you. I wonder if you're going under this particular fact, do you have an address for your spouse? Because I do need to stress at this point that having an address for the respondent is vital to getting your divorce through in any straightforward way. If you don't have an address, then you are looking at a situation which is either going to require a huge effort on your part, or again, you probably are going to need some specialist support from a lawyer, because there's a whole host of things that come into a divorce petition where it has not been served on the respondent. Because if you don't have an address, you can't get it served, the court can't get it served. And then, of course, one of the keys to a divorce, or really the most important thing that the court cares about, is does the respondent know that you've applied for a divorce? Have they received it? And if the answer to that question is no, because I don't know where they live, you're going to have problems, because a judge is going to want to know that every possible attempt has been made to find them. Even if they've moved to, uh, South America or anywhere, wherever, they could be in a tent in the Antarctic, the judge is still going to expect some effort to have been made to track them down. Now, you might be thinking to yourself, oh, well, that's easy enough. I've got their email. Okay. Well, yes, English law has been a little bit slow with that. A judge will potentially accept service by email if you can prove to them that this definitely is the email for your spouse. Okay, so it's not good enough to just come up with an email and say this is their email address. Can we email it? It's not quite that easy. And some of you watching this are probably thinking to yourself, oh, but I read an article where there was a divorce petition was served by Facebook. Yes, yes, I've read that one too. It was a one-off. It's not it's not easy to do. It can be done, but it's not enough to just tell the judge, well, this is my spouse's Facebook page. Can we serve the divorce petition by Facebook? You also, number one, you need to absolutely satisfy the judge that it's definitely their Facebook page, that you haven't set one up and pretended to be them. And secondly, the judge has got to be confident that your spouse is accessing their Facebook and is seeing things on it. So activity is important, to show that, oh, well, they're posting stuff all the time. So obviously, if I serve them a divorce petition, they'll have seen it. Not a case of setting up a Facebook page and never looking at it. So again, we're really into the territory of needing a lawyer here. So if this is the sort of thing that you're thinking, you're either going to have to turn into a very quick overnight expert in divorce law, or you're going to have to go and see someone who knows what they're doing. But the reason I mentioned all of that was because we were talking about the final fact of divorce, which was the desertion one. So the connection is that obviously if your spouse has deserted you, you may not know where they are. They just took the last flight out of Heathrow to the Amazon, and the last time you heard from them is that they were trekking down the Amazonian rivers. It's a problem that would need to be discussed. But if they have deserted you 2 years ago and you do know where they are and you have an address where they can be served, then that is excellent. That can be certainly used at this point. And I'm just going to finish off with the issue of service, okay, the service of the petition, because I've said so much about it now, about having your spouse's address. If your spouse is not living in England and Wales and they live in another country, there can be rules, and sometimes complicated rules, about how you can serve them. It really depends on where they live in the world. Okay, there are various legal treaties between England and lots of countries that make service in so many of those countries fairly straightforward. a lot of the European Union countries, service can be effected there fairly easily, sometimes even quite easily. Quite what the impact of Brexit is going to have on that, I don't yet know. It's not clear whether any of these treaties are likely to change. I would think they wouldn't, and I certainly hope they don't. But don't just assume that any European country is going to be like that. Switzerland has very, very complicated rules of its own. In fact, it's got rules for each canton, not even for the country. And there are other countries in Europe where serving people is deemed illegal and following them around and things. So if your partner is living abroad and if you think that they might ignore the divorce petition, then again, this is a subject that you may well need to take some proper legal advice on, because it's not as easy serving someone abroad as it is anywhere in England and Wales. If they're in England and Wales, we just need somebody, anybody other than you, anybody to hand them the divorce petition or even just throw it in front of them and testify that they did that. Okay, that's all they need to do in England and Wales. Anyone can do it. Your friend can do it. Your neighbour could do it. Your brother, sister, cousin, uncle, mother, father. Anyone can do it. You can't do it, but any of them can do it. Your lawyer can do it too. Just serve the respondent either by handing them the divorce petition and the acknowledgement of service form, or by literally putting it down in front of them and saying, "There's your divorce petition." But if they're not in England and Wales, then you should think about taking advice on that. So I hope you found this a little bit helpful or informative. If you're going through a divorce right now and you're thinking about filling in the petition, I hope that I've been giving you some pointers to what to do and what not to do in particular. If you found it helpful, please give it a tick up, give it a like just down below, and we'd be really grateful if you followed us. So thank you very much.